Taxation has assumed a significant role in the operation of governance in modern era. It is a collective trust contribution that allows government all over the world to fund public infrastructure, create and operate public institutions, and also cater for the emoluments of public servants. Taxation, therefore, is a fundamental aspect of funding to government imposed on eligible adults and business organizations.
You think that came from a tax administrator? No. That was Justice Mary P. Toddley, Justice of the Supreme Court, speaking at the opening ceremony of the Interactive Training Conference held for judges of the Federal High Court and of the National Industrial Court on Monday, the 4th day of October 2021. And if you ask us, it shows that the judiciary fully understands the veritable place of tax and taxation in the affairs of any nation. The program is Tax Matters, and I am Chamaka Ohaochi. If you recall, last episode we shared with you the story of one of the two training conferences hosted by the National Judicial Institute and the FRS for judges. In that first instance, it was the session with justices of the Supreme Court and those of the Court of Appeal. Today, we will tell you the story of the one held for judges of the Federal High Court and the National Industrial Court. By the way, the Federal High Courts are designated as revenue courts in Nigeria. Against the background of the theme of the training conference, the role of the judiciary in the enforcement of tax laws, 3 papers were presented. Honorable Justice Benedict Kanyip, President of the National Industrial Court, presented the first paper on the theme. The session was chaired by Honorable Justice Binta Motalanyaku, who stood in for the Chief Judge of the Federal High Courts.
We are supposed to talk about how to secure key judicial appreciation of taxation as the life wire for sustenance of Nigeria. We are all living witnesses to the state of the economy. Money meant for governance is now lower than what we are used to. It is in this sense we are called upon as judges to appreciate taxation as the life wire of the sustenance of Nigeria. But the question that arises, which I've been asked to talk on, what is the role of the tax judge? Now, taxation is often a tussle between the taxman and the taxpayer. The question is always to pay or not to pay. Even when it is to pay, the question devolves on how much to pay. This brings to the fore the contending theme of tax avoidance in the law of taxation. Some choose to call it tax planning. Here, I'm not talking about tax evasion, because tax evasion, everybody agrees, is outrightly criminal. Tax avoidance or tax planning has its roots in the interpretation of taxing statutes. Of course, one of the first things we are told as judges is that the function of interpretation is a judicial function. It's not that of the executive, it is not that of the legislature. So, if an issue boils down to interpreting tax statutes, then that is the primary responsibility of the judge himself. While the taxman wants to get as much tax as he can from the taxpayer wants to reduce his tax liability to the barest minimum as he can order his affairs. Should the tax judge go with the taxman or the taxpayer? This is always the dilemma of the tax judge. When we talk about specialization, we talk about judges who have what we call generalist jurisdiction, and then courts that have special jurisdiction. Everything about Section 251 of the Constitution dealing with jurisdiction of the Federal High Court deal with special matters. So in that sense, Federal High Court is also a specialist jurisdiction. But it's very difficult to have judges in Federal High Court who are specialists of all the items. So there's this saying, if you cannot specialize the court, specialize the judge. Now, within the structure of Federal High Court, I personally don't see anything wrong with having some who are specialists in revenue law. I don't see anything wrong with having judges who are specialists in maritime matters, those who are specialists in company and allied matters and the likes. It allows for specialization and so on within that field. Now, for us to know our role, I need to also discuss issues regarding tax policy. So, the next part of my presentation deals with tax policy, by which I define as the choice by a government as to what taxes to levy, in what amounts, and on whom. This can only be understood within the structure of the objectives and functions that taxation must serve in any given economy. Now, the saying is that there are two things that are certain in life. One, death. The second, taxes. But as certain as tax may be, it must be within the parameters of the law. In this sense, taxation must be statutory and has to be imposed pursuant to legislative authority. Now, howsoever taxation is approached either in terms of study or adjudication, two approaches are self-evident, which I pointed out earlier. It's either you are pro-avoidance or you are anti-avoidance. It's just not possible to study taxation or to adjudicate on taxation on any other. There is no sitting defense. It's either you are for or anti. So, the first function of the tax system is said to be raising revenue to meet government expenditure. So, the legislature goes through the hawk of lawmaking because they want to raise revenue. Does it sound logical that any other interpretation but raising revenue be read into that tax statute? The legislature set out to raise revenue. That's why they passed the law. Can that law come before us as judges? And the next thing we are saying is that the legislature could not have intended that this receipt is affected. So, if raising revenue is the key function, it presupposes that whatever interpretation will give effect to that purpose ought to be the stance taken.
Justice Kanyim proceeded to draw a nexus between tax compliance and the eligibility of persons to hold public office.
Tax can also be used in our political sphere. Now, for you to be able to contest an election, you are asked to bring tax clearance certificates for the past 3 years. The idea is that if you're a tax defaulter, we should not entrust elective office to you. But have we really used it the way it should? My analysis in terms of the cases that went to court show that only in one case that I know of where the issue of non-payment of tax was used to scuttle an election. But even when it was scuttled, what the court did was to order another election to hold. And my viewpoint on this is very simple. In fact, I share the view that the easiest way to fight corruption is through taxation. You say the man has monies he cannot explain. Ask him a simple question. How much have you paid as tax? Because if you really understand what tax law is about, every receipt is taxable. In tax law, if you indicate, I gave tip as X amount, every month this hotel is supposed to aggregate all that amount of money that came in as tips. there is a sharing formula for all those who are entitled to it. And once they get it, it is an additional income to their tax liability. Taxation does not depend on the legality of the activity. Even illegal transactions are subject to tax. That's why prostitutes are taxable. Yes. The fact that you are engaged in an illegal activity, if a profit inures out of it, you are subject to tax. It's a basic tax principle. So legality does not determine tax liability or the incidence of tax liability. So my stance is, if we want to fight corruption, you can do it more easily. Those of you that follow prohibition days in US, the mafia world and so on, majority of the mafia warlords that were actually imprisoned in US, they couldn't imprison them because of any organized crime or whatever. It was simply because of non-payment of tax. Because that's the easiest way for which to hold somebody responsible. The man comes and you see him driving a very flashy car. They say, how much is this car? $1 million. You don't ask him how he got his money. Simply ask him, how much have you paid as tax? The moment he cannot answer, and don't forget, even delay in paying tax is tax evasion, not to talk about not paying at all. That's why I said our discussion in terms of rule is not so much about tax evasion. It is so much about tax avoidance. Secondly, I read cases where the argument was that the man has not paid tax, so disqualify him from standing election. And us, when I say us, I mean us as judges, said no, we cannot disqualify him because INEC had cleared him. How can the clearance of INEC be evidence of payment of tax? It's something I still can't come to terms with. Don't forget, we are dealing with people you want to entrust elective offices to. You are dealing with people whom you are entrusting your posts. If it's a National Assembly person, he has power to appropriate. If it is in the executive, he has power to spend. Now, if you don't get the right people there, and we use one funny rule to allow them to escape, we have no business complaining when they start dealing with the post the way they want.
It's getting hot, isn't it? This is not about anybody in particular, but all of us, everybody. Tax compliance is sine qua non. We are sharing with you what transpired at an interactive training conference for judges of the Federal High Court and National Industrial Court held in Abuja on the 4th of October 2021. We will go on a short break, and when we come back, Justice Kayimp will still be on stage.
I'm a very busy man. My business involves a lot of traveling and I interface with lots and lots of people and organizations. Tax compliance used to be a big drag on my business. It was time consuming and very costly. But now, no more. Introducing the FIRS Tax Pro Max, the truly fully end-to-end tax administration solution for companies' income tax, value-added tax, petroleum profits tax, and all other tax types. For fast, efficient, and convenient end-to-end tax experience, log on to www.taxpromax.firs.gov.ng. Tax Promax has turned things around for me. It is fast, user-friendly, and cost-effective. FIRS, making tax administration as easy as ABC.
Justice Kayimp concluded this way.
Some measured proactiveness on the part of the tax judge is expected. A taxing statute is first and foremost a taxing statute because it seeks to exact money from the taxed. This is the intended and primary purpose of the taxing statute. All other purposes of taxation are ancillary to this aim. So, when the tax deliberately arranges its affairs as to escape tax liability or engages in what is called abusive tax avoidance schemes, this must be frowned on. The tax judge must therefore look at the paradigm within which he works. Australian judges, for instance, have been reported to have no love for tax avoidance even when they strive to maintain a judicial balance. And Japanese judges are said to indeed play a significant role in the tax law-making process. Judges have thus been asked to act as pragmatic tax analysts, in which event they should not ask what the legislature said, or mean to say, or trying to accomplish, but simply what result would reflect the most sensible tax policy, and then adjudicate on that basis. But at the other hand, I have read of fears being expressed against what has been termed as judicial taxation, with very strong reservations made, i.e., that judges do not have power to tax. The tax judge thus is cautioned against the dangers posed. And what are the dangers in judicial taxation? For instance, that he may decide a case by reference to his own morality or sense of justice. The problem being that morality differs from person to person. Additionally, the outcome of decided cases may not be the product of the application of some predictable principle. Now, I said, while predictability and certainty may be called for in especially the world of business, in other words, like cases should be decided in like manner, this is something we should not stretch too far. The general principles as to what is taxable income or what are allowable deductions are often expressed by the legislature in general terms. The very fact that we cannot even define income, for instance, means that each case must be decided on its own merit. What is income? If you go to Personal Income Tax Act, income is defined as that which is deemed to be income under the Act. I'm sure that's not a helpful definition. If you read some of the case laws, they define income. One judge defined it, if I may be pardoned for saying so, is a tax on income. It is not meant to be a tax on anything else. Another said it is that which is taxable under the Act as income. Another said income tax is a tax on that which comes in, as distinct from that which goes out. How helpful is that? And what people fail to understand is that every tax case that comes before you is judicial lawmaking. The fact that you hold the receipt taxable or not taxable is itself lawmaking. And why is it lawmaking? Because the legislature never made specific provisions. The provisions are general. It's up to you as a judge to enlarge the scope of receipts taxable or delimit the scope of receipts taxable. But each time you make a decision, it's always a new law. Every tax decision in itself is a new law being made. So those who talk about or who talk against judicial taxation are simply doing that because they don't even understand the parameters, the intricacies involved in making tax determinations.
The second paper of that day on effective methods of tax dispute resolution was presented by Professor Abiola Sani of the University of Lagos, while the third paper on the Federal High Court FRS Practice Direction 2021 was delivered by Honorable Justice Eyang Eho. For a taste of what is to come, for a taste of what transpired at the interactive session, this from the Executive Chairman FRS. Reacting to the issue of tax compliance and tax clearance certificate raised by Justice Kanyimp, Mr. Nami had this to say.
Some of the TCCs that these people are tendering, for them to be able to occupy these positions in some cases are fake. So if somebody wants to get into position of power, and the first thing is tendering, is a fake document, what will be the fate of this country if that person gets to that position of power? If the tax clearance certificates are not fake, there are possibilities that the taxes are paid in arrears. If you are paying taxes in arrears, the first thing that comes to our mind as FR is that you are not just a tax avoider, you are also a criminal as far as we are concerned. Another thing you should look out for if you are looking at tax clearance certificate is the fact that you discover that one person will pay taxes for 3 years in a day. So an assessment will be given to him for 2018, 2019, and 2020 years of assessment. He will walk to the bank and make that payment in a day. That is already an issue. If not because he wants to occupy this office, he wouldn't have paid at all. So you have the power to ask him, where were you in 2018? Where were you in 2019? And what happened that you did not even pay these taxes in 2020, you're only paying in the year 2021?
In rounding off today's episode, we want to go back to the opening ceremony that preceded the paper presentations. Mr. Muhammad Nami, Executive Chairman FRS, welcomed participants to the interactive training conference.
This conference is a platform to exchange ideas, build trust, and partner together to develop well-set strategies for tax dispute resolution that will promote certainty, transparency, and public confidence in our tax system. The authorities in charge of tax policy, tax legislation, and tax administration must collaborate with the judiciary in order to move the tax system and the nation forward.
Justice Galbra Abdullahi Salisu, Administrator of the National Judicial Institute, delivered the opening address.
We are all aware that the Federal Internal Revenue Service is on the path to drive and boost the country's economy through improved tax collection, particularly with the Bureau of Rapid Growth of E-commerce in Nigeria. This being a good initiative, however, will come with its challenges, particularly in the area of interpretation of the tax law. This will require the court to serve as a final arbiter in law to resolve any conflict. The judiciary must be well prepared and equipped to provide dispute resolution method in order to effectively deliver justice.
Special remarks were delivered by Justice Benedict Kanyimp, President, National Industrial Court, and Honorable Justice Mrs. Binta Motala-Nyako, who stood in for the Chief Judge of the Federal High Court.
We at the Federal High Court, being, first of all, Revenue Court, before we metamorphose to what we are today, are the people who are to benefit most from this interactive session. We have been working, particularly during vacation, on a lot of issues to do with revenue and tax issues. That the Federal High Court is forever there to do tax matters. We give it priority because we know the importance of tax and tax collections for the country. So we are always at the service of the nation to do cases as they are presented before us. Of course, we're not going to go on the street and pull cases and say, come and do case before the court. But whatever cases have come on before the court, we can assure you that nobody's going to shy away from doing the job, and nobody's going to shy away from their responsibilities.
Honorable Justice Mrs. Mary P. Todley delivered the keynote address and declared the conference open. There you are. Judges being brought up to speed to enable them to do better what they are already doing well. We assure you that we'll keep our promise to share with you more from that training conference. That will come very soon. Thank you for watching. See you next time.